Hey everybody, good afternoon. Thanks for joining us today. Sorry, a couple minutes late. Just had to get everything put together and waiting for a couple people to jump on. But we're here now, and we got a kind of hot topic here. There's been a lot of discussion about OTAs. We've done some articles on it. We've gotten a lot of interest. So we figured we put together this webinar, Josie and I, to kind of walk through, where things are right now and kind of what people should know about OTAs, how to access them, some of the best practices, some of the policy guidance around them that isn't as clear, and just kind of talk through also our experience and some of the anecdotal information. So I'm Alba. I'm a partner in our GovCon group, and I'm here with my colleague Josie. Josie, do you want to introduce yourself?
Hi everyone, I'm Josie Farinelli. I'm an associate in the GovCon group.
Perfect. Well, and I think, you know, Josie and I, again, like I said, we've been dealing with a lot of these sorts of issues in our practice. And it, as on this slide, right, for all the different practice groups we have, it sort of overlaps things because you usually create these, so that they're run through consortiums, and a lot of times we help with setting them up or changing them, working through the governance documents of them, which has a corporate tinge. And because these are fully negotiated, which we'll get into more detail on, all the FAR issues and some of the regulatory requirements just don't exist. So it's much more of a commercial agreement, even vis-a-vis the government, third parties, if there's a third party consortium. All of these things are negotiated agreements. So it touches on still some government contracting issues because there's a lot of flow downs that the government uses just as shorthand, even though they don't technically have to apply. There's IP and data rights issues that are largely governed by commercial and state law questions. Then there's also corporate issues with the structuring and governance of these types of matters. So there's a lot of overlap with our various practice groups. We usually kind of come together, although I straddle a lot of those myself. So we work with these things quite a bit. And so with that, let's kind of kick off the substantive things here. And Josie, why don't you take the lead and start taking us through some of these things?
Sure, so let's start with the reason that we're even talking about this. EO 14265, modernizing defense acquisitions and spurring innovation in the defense industrial base. So, we've got a few bullet points here, but the gist of this EO was that on June 8th, the Secretary of Defense was required to submit to the President a plan to reform DoD acquisition processes to eliminate inefficiencies. So, the biggest and most important part of this plan for our purposes here is that DoD was required to utilize existing authorities to expedite acquisitions, including, and this is a quote, a first preference for commercial solutions and a general preference for other transactions authority. So there's certainly a lot of reason to expect the DoD is going to utilize OTA more in future procurements. And I think even before the plan was enacted, they were instructed to start working towards it right away. So
And what's interesting about that is while the administration is pushing for more use of OTAs, folks on the Hill on both sides of the aisle. So this is not just a minority issue, this is the majority as well. They have concerns that the increased use of OTAs might mean a decrease in visibility and transparency over spending and key priorities. And so the House and the Senate are likely going to push something through in the 2026 NDAA to require additional reporting to Congress to allow for greater oversight. So while the administration wants to streamline, go faster, do things more quickly, there's already pushback on that because of the desire for oversight and transparency. And I think that's just a theme I think we're really going to see with all these FAR overhauls too. The fact is, if you want things faster, quicker, easier, what that means is more fraud, more abuse, less transparency, because if you go fast, things fall through the cracks. And so I think we're already seeing that pendulum swing, and it's just something that's going to continue. So just a point of note.
Okay, so this is the question that's on everyone's mind, and we've got a very general definition here, but what is another transaction? Um, it's a transaction other than a typical government contract. That's the simplest way of putting it. It's not a FAR-based procurement or contract. It's not a grant. It's not a cooperative agreement. It's not even a commercial solutions opening, although, sometimes those can result in prototype OTs. Next slide. So OT generally refers to the statutory authorities allowing the federal government to enter into transactions um, other than a typical government contract, like I was saying. And while this presentation is focused on DoD's OTA, several other federal agencies like NASA, DOE, HHS, and DHS have their own OTA. 10 USC 4021 and 4022 govern DoD's OTA, and they also form the basis of a lot of the other agencies. So while the statutes we're going to discuss today are specific to DoD, the broader concepts of flexibility, desire for non-traditional contractors to participate, use of consortia, the ability to negotiate award more like a commercial situation, those have broader applications across other agencies. So to start, DoD has three types of OTs. There's the research OTs, which are basic, applied, and advanced research projects. Often, if those are successful and the government likes the outcome of the research, they can turn into prototype OTs, where the contractor can develop a prototype based on their research so that it plays into DoD's projects or capabilities that they're trying to develop. And then, if the prototype is successful, it can result in a production OT, which is a follow-on to, the research and prototype OTs are usually competitively awarded. Production can be a follow-on, usually sole source to whoever does the successful prototype OT.
And to Josie's earlier point about other agencies too, just to note that you might, if you've had experience with NASA and their Space Act agreements or CRADAs and other DoD contexts, or like SBIRS, TTR, the SBIRS, TTR have very specific regulations that deal with them, but things like the Space Act agreements and some certain things like certain CRADAs, while there are laws and regulations, they're also more commercial. So that's just another piece to note that those aren't technically OTAs, but they share similarities in that a lot of things are negotiable, especially like data rights, IP protection. Those things can be negotiated and negotiated fully. So always remember that. There might be clauses that they put in, or they try to say there's certain non-commercial elements to it, and therefore they try to float on FAR clauses. None of those things should apply in any of these contexts.
So building off of what another transaction is, we're going to talk about some of DoD's goals. They have 6 stated goals, and as you'll see, they all sort of revolve around flexibility, speed, and participation by non-traditional defense contractors, which we'll refer to as NDCs. So the 6 goals are: foster new relationships and practices involving traditional and non-traditional defense contractors, broaden the industrial base, support dual-use projects, encourage flexible and efficient product design and development, advertise DoD's priorities such that industry will start to align and incorporate those priorities in the work that they're already doing, and collaborate in innovative agreements. So you can see that given the stated purpose of DoD's OTA and the flexible framework for making these OT awards, it's easy to see why the Trump administration's EO focused on streamlining defense acquisition and getting rid of the proverbial red tape would include an express preference for using OTA. The concept is meant to be inherently efficient. So we'll get into who can participate in OTAs. While OTs are not subject to traditional contract requirements like the FAR or the CDA, DoD generally defaults to promoting competition on other transactions, particularly for research and prototype other transactions. in lieu of a sole source other transaction whenever possible. And competition is actually especially important for OTA, where one of the stated desires and goals for DoD is participation from NDCs.
And to the point about the initial stages of prototyping and things, it makes sense, right? You're looking to figure out what is the best solution. And so as part of that, competition is a great way to do that. You get multiple people coming to the table, expressing different solutions to solve a problem, and then the government can pick and choose, or potentially pick and choose multiple items if they wanted to fund various areas. It's not dissimilar in that respect to some of the SBIR context. Sometimes you'll see multiple of those going on at the same time for specific needs. And then usually the government sees which one works out best, or if it's competed and they pick a horse right out of the gate, if it works out, then they can move into different phases, just like here with the OTAs. And once you get to that phase, because of the intellectual property rights that are generally negotiated to stick with the prime, it makes sense that the follow-on is then sole sourced. So that's sort of the basis behind why you've got more competition at the front stage than you do at the back stage.
Right. And we're going to take you through that a little bit now with, the specifics about what's in the statutes about research, prototype, and production OTs. So starting with research, it's governed by 10 USC 4021. Like Sai was saying, they're generally well suited for merit-based competitive procedures, though, unlike a typical FAR-based competition, the agreements officers for research OTs have, a lot of flexibility in how they generate that competition. And aside, this goes to the point, aside from the desire to involve NDCs, there's no specific mandate in the statute to have them participate or even structure a research OT procurement in any sort of way. As long as the basic, applied, or advanced research project doesn't duplicate other DoD research and is funded at least 50-50 by government and other sources, DoD really has very few statutory limits to award a research other transaction award. So the next step would be a prototype other transaction. That's where small businesses and NDCs really stand to benefit from recent efforts to reform defense acquisition, because participation is limited a little bit more by 10 USC 4022, which covers the prototype and production OTs. And that's because at least one of the following three conditions must be met to award a prototype OT. First, there's at least one non-traditional defense contractor or nonprofit research institution participating to a significant extent, or all participants in the transaction other than the government are small businesses or non-traditional defense contractors, or at least 1/3 of the total cost of the prototype project is to be paid out of funds provided by parties other than the federal government. And one quick thing to note about prototype other transactions is that the Trump administration is also encouraging commercial solutions openings, which DoD was already ramping up because the 2024 NDAA mandated DoD to use CSOs at least 4 times per fiscal year. And like I said before, while CSOs are not the same as an OTA, sometimes the CSO can result in a prototype OT award if the contracting officer sets up the CSO and the areas of interest under 10 USC 4022. So just another quick thing to note that, sometimes other transactions authority is off on its own, and sometimes it can result from a CSO. So another source to look if you're interested in award. And finally, the third type of other transaction is a production other transaction. Those may be awarded pursuant to 10 USC 4022F, and this is where you can get into the sole source like Sai was discussing. Award may be made to the prototype OT awardee without additional competition, as long as competitive procedures were used for the selection of the prototype award and the prototype awardee successfully completed the prototype. Another thing to note is the award may be made to a consortium if DoD determines that the participants successfully completed an individual prototype or prototype sub-project as part of the consortium. So now that we kind of have a general sense of what OTA is, the question is, where do you find these OTA opportunities? DoD encourages the agreements officers to advertise information about OTs as widely as possible because again, one of their main goals is to reach non-traditional defense contractors who might not be, combing through sam.gov as much as a traditional contractor would. That being said, sam.gov is still a great place to start, especially like I said, CSOs and areas of interest can result in OT awards, so definitely worth taking a look there. Additionally, there are agency websites and social media platforms like LinkedIn and Facebook where they're posting this stuff a lot. And there are crowdsourcing and market intelligence campaigns. I have AFWorks up there as an example because they post a lot. And additionally, like we were saying about consortium before, there are existing accelerators and consortia that have websites viewable by the public where you can see they've posted OTA opportunities and they've posted about their prospective members, and something that you could look at just to see the opportunities or to consider joining.
Yeah, and on that last point, it's not as simple as like, hey, I see this opportunity on this consortium website. I'd like to join up, and how do I do that, right? The consortium are all independent independent entities, right? And they have their own rules and their own way of governing themselves, and whether or not they will let people in or not let people in, or what the procedures are for getting in, what the procedures are for them awarding or choosing potentially who gets certain items, whether they're holding competition at the lower level, who gets the notice, all of that stuff is very much dependent on each of the different consortium. And I've seen them done in various different ways. And some are more hands-on and some are more hands-off. The larger consortium that are usually larger nonprofit entities almost just serve as traffic cops to work with the particular members of the consortium to help make certain awards. Whereas there are smaller consortia that are almost more like joint ventures in a way, not exactly, so it's not the same thing, but they're put together in a way where there's more collaboration with at least a subset of these consortium members, or potentially all the consortium members. And that just gets back to this whole idea that an OTA is not a regulatory based thing. It is a commercial document and a commercial agreement. And that sort of filters down through every level of this so that you can structure it however you want it to be structured in a lot of ways, subject to negotiation. So there isn't any particular way things have to be done, which I think government contractors sometimes pulling into this space because of the increased use of them sometimes want to know, well, what are the rules? Because there's got to be a rule, right? Not necessarily. There's not always rules here. This is very much more like if you're negotiating an agreement completely outside of the government contracting space. Now, of course, the government, as shorthand, like I mentioned earlier, might try to flow down clauses, and there's plenty of reasons why you should push back on that or try to negotiate because there's no requirement to it. But you should be prepared to have to come up with drafting new language or fully negotiating basic terms that you would never do in a standard government procurement.
So next we're going to get into what a consortium is. In the context of OTA, a consortium is a relationship between a group of traditional and non-traditional contractors, nonprofit organizations, academic institutions, and there's pretty often a government sponsor like DISA, DARPA, SOCOM, where the government sponsor will have a relationship with or sponsor an agreement with a specific consortium, and that consortium kind of has this ongoing like collaborative relationship with the government where they're constantly like discussing government driven problems and consortium driven solutions, or the consortium just is really following those DoD goals where they're learning what the government needs and they're proposing solutions on their own. So the group is formed to pursue research, prototypes, and products in a specific technology domain where DoD has identified goals, shortcomings, or some other need to innovate. So, maybe your area of expertise is engineering or aircraft or, like software, anything that you sort of have in common can form the basis of a consortium. They can also be managed by the government itself, like I was describing in a sponsorship situation, or by one or more of the consortium members. We've seen a lot of OTAs where there's, like one member is sort of a belly button doing the administrative work and passing work to other members. And like Sai mentioned, there's also ones that are run more like traffic cops. But ultimately, the important thing to keep in mind is that a consortium is a group of innovators who are focused on collaborating to solve technology issues identified by the government sponsor. It might be a refreshing thing for government contractors who are interested in this space but are used to going it alone on FAR-based procurements. So definitely something to consider. So there's this big question of how consortia are structured, and the answer is however you want. I mean, it's up to the government. So the name of the game is flexibility. Neither of the statutes setting out OTA define or limit the types or uses of consortia with respect to other transactions. So DoD reverts to flexibility. And the Office of the Undersecretary of Defense for Acquisition and Sustainment put out an other transactions guide, I think in 2023, that encapsulates this idea pretty well. And it states that DoD's priority for OTs is identifying and teaming with capable partners. This includes traditional defense contractors, non-traditional defense contractors, academia, small businesses, a combination of all of these different organizations working together to achieve a common goal. So it really is kind of the wild, wild west, and these DoD agreements officers have broad authority to determine which
Oh, did we lose? Yeah, I wasn't sure if it was just on my end. So while Josie's coming back, I guess, yeah. So these issues are, again, like I said, they're wide open here, and you have to be prepared to deal with that, which is again very uncommon for government contractors. A lot of times there are very specific rules on how things are put together, and um, that being said, oftentimes as well, when DoD is really trying to push things, some individuals inside of DoD will have um, more invested in wanting to control things. It's like anything with human beings, or if you're negotiating something with subcontractors, right, or other commercial companies. Some commercial companies are really relaxed and some aren't. And just because the government is one unified body doesn't necessarily mean they treat things the same way, right? Different individuals will have different views on how things should be put together. And that's not completely uncommon in the DoD space where they're given a lot more freedom, where you're talking like DCSA, for instance. There's a lot of just broad policies there, but a lot of discretion is given to those guys into how things should go. And when you're talking about places like DARPA and you're talking about cutting edge technology, they're really trying to push for maximum flexibility and allowing the government to get what they want through negotiations, just standard negotiations like you would with commercial companies. And so when you have that kind of scenario, you get these things where it's not always very clear how exactly everything has to be structured. But with that freedom, while it can be unnerving sometimes, it also gives you the great ability to actually negotiate with the government, not a negotiated procurement under FAR Part 15 or something, right? It's an actual negotiation. Everything is theoretically, at least, on the table. And if they put their foot down on some particular item, you can push back. Now, it might mean that you don't get the award, or if it's a competitive scenario at the prototyping phase and other competitors are giving the government purpose rights, for instance, that could be a really important thing. And the consortium rules may or may not allow for that. Sometimes it requires, or it's been pre-negotiated, what the IP data rights are supposed to be on certain things, and other times it's a contract by contract analysis, right? And when you have something like that, you just need to be prepared to enter into negotiations in a way that's very different than your traditional negotiations. Sorry, yeah. Josie's back. You can go ahead and
Yeah,
continue
sorry I
going.
dropped off there for a second, everybody. I don't know what happened, but luckily Sai's the expert and was able to, pick back up where I left off. So um, I think we can move on to the next slide. I think we probably covered this topic. The ultimate question here, now that you've listened to us talk about consortium for a few minutes, is, should you join one? And, we wouldn't be good lawyers if we didn't say this is a business decision for your team to make. You're going to want to weigh that on a consortium by consortium basis. And if you find one that's a good fit for your business, it could be a good way to get your feet wet if you're new to OTA. There are a few possible benefits that we see. One of them is the opportunity for limited membership and streamlined administration. So, like we were saying, some consortia allow for other than full memberships. You could be an associate member who is just there to handle specific tasks, maybe your speciality, and then full members maybe don't have the interest or bandwidth or experience to take those pieces on. And consortia typically have streamlined processes to navigate OT awards more quickly than traditional government acquisition programs or even other OTA procurements. Many even have a lead member that handles some of the administrative burdens so that other members can focus on performance. So sometimes, if you get one of these associate member positions, you can kind of focus on the fun part, the innovating, while somebody else handles the admin. Um, One of the other benefits is collaboration with like-minded business partners. So that's, obviously one of the biggest things here. If your business is interested in this space, it's an easy way to, meet other businesses who have those same interests and grow together. There's also an open dialogue with the government. It's like I said, they are sort of giving you an idea of the problems that they need solutions for, but they also want you there to identify problems before they see them and adapt industry to DoD's needs. So it's a great way to sort of make connections and see kind of what's coming down the pike and what the government needs so that you can structure your business around that. It's also a potential foot in the door for future OTA awards. While being a member of consortium does not guarantee an OTA award, it's at least a relatively easy place to start your search and garner slightly more direct access to government programs that are seeking other transaction solutions. For contractors who are used to going alone on FAR-based procurements, the collaborative nature of a consortium could be a welcome and exciting change. And at the end of the day, they offer what's essentially a built-in network of like-minded businesses with knowledge and resources and everything that those other businesses have to offer. So members can partner to propose solutions and pool their collective experience to drive innovation.
Yeah, and at the same time, you got to make sure you're being careful, like reading the documentation and what it means to be a member, an associate member, or what you're required to do and provide. A lot of the things that, not to harp on this constantly, but some of the data rights issues is what I see most when it comes to these OTAs, because you're creating something brand new that might have commercial applications. And the consortium might require you to turn over certain rights to the consortium itself or have like co-development rights. And when you're dealing with something like that, if you had something really innovative, then yes, you would have that opportunity to take advantage of it, get your foot in the door. But at the same time, if you have a clear path already, or you think you've got something very, very unique that the government might want, it would behoove you to attempt to push forward and try to potentially get your own, set up your own concern. Nothing's stopping you from doing that necessarily if you have the contacts with the government and you've got really unique product or opportunity. So just remember that as well.
Next slide. Yeah, and to Sai's point, there are also risks associated with joining consortium. They're not all created equal. And before you join one or consider joining one, you're going to want to carefully review the articles of collaboration or any other membership agreements to ensure that you're joining with clear eyes. Some of the possible risks are membership fees. There are some membership fees that are relatively low, some that are possibly prohibitively high. There are also government or research-based constraints that you might run into with a consortium that you might not run into on your own. And then there's also consortium can have a limited purpose. So if you have dreams or aspirations or products that go beyond what the consortium can do, you know, it might not be the best fit for you. That being said, you may find that the benefits of joining outweigh any downsides or risks, especially if you're new and you don't have a new or innovative project or product that you already have in place and can push, like Sai mentioned. So, you know, just it's always better to know and mitigate risks ahead of time. So to the extent that you're looking to join one, definitely, pull in your team, get all the advice you can, and join with clear eyes.
Yeah, and there are a couple questions that are being asked here. So first, how do people know whether or not the consortium that they're looking at is kind of a good fit? It's very much like when you're doing a business relationship, so long as the fundamentals of the consortium fit what you're doing, right? So if it's for some sort of anti-drone technology and you have no experience, you've never done that at all, you have no interest in it, obviously, then that wouldn't be a good fit. So that's first. But then after that, it's trying to look at the stuff that Josie said to make sure that it's something that seems compatible. Meeting with some of the members, talking about how things are done, even seeing if they'll let you talk to some of the other consortium members at different levels, specifically the level you want to come in at, to see how things are run, how is it organized, how are they treated, all of those kinds of things. So very much just like if you were vetting someone for a teaming agreement, I think makes the most sense there. In addition, there are questions about whether or not when you're going into the sort of OTA phase, if there's been construction OTAs. I personally have not seen any directly, although I did have one item that was with like a modular building technology. And so it wasn't necessarily the construction of a facility that they needed through OTA, because again, the basis for this, not dissimilar to sort of SBIR, STTR, those sorts of things, are to develop like innovative solutions and have new cutting edge work, which is why you see DARPA and a lot of them do it. But if there's specific technology that's being brought to bear, even if it's quasi commercial already, like in this case I'm thinking of, where there was this like on site modular construction method that was being used, and the government was very interested in it, especially because it potentially had battlefield uses as well, where raw materials could be converted on site. So those sorts of things are more along the lines of what I think you'd see, as opposed to just, we're building a building or something like that, like a general construction project, because you don't have that other element. And then lastly, there's a question about what sort of work you would go after. If I'm an 8A company or if I'm a serviceable vet company, is that better or is OTA better? They're just completely different. They have really nothing to do with one another. All the set-aside rules don't directly apply to OTAs because all the set-aside rules are based in FAR Part 19, and FAR Part 19 doesn't apply to OTAs. So none of these things that are like set-aside ideas and things like that apply directly. However, any small business is considered, as Josie was mentioning, a non-traditional contractor. So you automatically qualify as being eligible if you are small. So that's really the connection. And it's not something where I would say, oh, don't focus on 8A procurements and sole source awards under the 8A program or competitive 8A procurements and that. Go focus on OTAs. If what you're looking to do is subject to an OTA, or if it's very innovative and you need government funding, but you want to be able to negotiate the intellectual property rights in a more broad and robust manner, that's really where I think it would make the most sense to try to push the OTA model. because if you have standard production contracts, or development, I should say, contracts, where the government is funding the development of certain intellectual property, they're going to get either unlimited rights, this is outside of SBIR or STTR, they're going to get unlimited rights, or they're going to get government purpose rights if it's sort of mixed funding. And that might not be ideal for you going forward in the future, whereas under the OTA context, it can be negotiated. So again, that's sort of the fundamental issue that I see more than anything else when you're asking these sorts of questions. But it's certainly not one where you would pick, well, I'm going to be an SDVSB or I'm going after OTAs. I mean, whatever works and what you see out there, especially in this environment, I think it's a good place to diversify.
All right. Well, I think our next slide, so I pretty much already covered in response to Mr. Bauer's question, but just one more note on consortium before we move on to our next topic is that if you truly are totally new to this and lost, where do I start looking for consortium at all? It sounds incredibly simple, but an online search just using OTA consortia will pull up lists and lists and lists of existing consortia. And you can go on their websites and you can see the sort of projects that they're working on. And, like we've been saying, they're typically purpose built to address, a specific DoD concern. And you'll be able to see pretty quickly which one aligns with your business. And, like I said, that's where you start doing your due diligence to make sure it's actually the organization that you want to join. So I think with that, we can start talking about negotiating an OTA award. If your game, Si.
Yeah.
So, like we've been saying, flexibility is the key to DoD's OTA and to achieving its goals of engaging with non-traditional defense contractors, advancing innovation, and implementing efficient business practices. Like we've also said, the FAR, the DFARS, the Competition and Contracting Act, SECA, they don't apply to OTs. DoD has significant flexibility in structuring the OT award, and this is kind of to your benefit. You get to cut through a lot of the red tape and negotiate, keeping certain FAR clauses out and other things that, would normally kind of hamper you in a government contracting situation. So if we go to the next slide. Aside from terms that are required by statute, the government agreements officers and the contractor can collaborate from the start by negotiating the terms of the OT agreement. Whether it's for research, prototyping, or production, contractors should carefully negotiate the terms of the agreement and consult with experienced counsel before executing it. And there are really, you can push back on anything and anything as long as it's not in the statute. But for the purposes of this presentation, we think that there are 3 areas that can really make or break an OT award, and that's intellectual and physical property, modifications, disputes, and termination, and payments, accounting, and auditing. So if we want to get started, we can talk about intellectual property. Like Si's been saying, innovation is inherent to OTA. So it's important for contractors to note that unlike FAR-based awards, OTs aren't subject to the Bayh-Dole Act, which governs the government's rights in inventions and patents, as well as other DoD-specific requirements regarding licensing rights in technical data and computer software. So while the government is likely to begin with FAR and DFARS provisions, a lot of these agreements officers, they're contracting officers. It's difficult to be out there without anything to start from. So it's a fallback to get to the FAR. Contractors should negotiate around and make sure that they're addressing the following: the contractor's right to retain ownership of any IP it develops under the other transaction, the government's license rights to any IP developed, the contractor's license rights to the IP it develops, and whether the government will receive any license rights to the contractor's pre-existing IP if that IP was used in performing under the OT.
And that last piece is critically important when you're dealing with team members as well. I've seen it too many times, both in and out of the OTA context, where the prime contractor doesn't negotiate the same level of rights in intellectual property that it is promising, whether it knows it or not, to the government. So if you're simply excited and you're taking the agreement as written and you're not thinking about, or you're promising certain elements of different intellectual property, or you have ideas and concepts, and then later you're bringing in parties and negotiating certain license rights with them, you need to be very, very careful that whatever you've promised to the government, you have that same obligation from your subcontractor. So either they're giving rights directly to the government, they're giving enough rights to you to do what you need to do to fulfill the OTA, but then also even after that, if you're making promises to the government about certain rights and title, that you're able to deliver that because you yourself have received it, or you've received a document that allows you to pass it through directly to the government. Because if you don't, you're going to be in default. And that's obviously, you can create terminations and costs and all kinds of issues if you have that scenario going on. And on top of that, you can get sued by the subcontractor for infringement and other things as well, especially if the government starts using it. And I've seen that recently, where the government says, well, you gave it to us, so we're using it. Then we've represented both primes and subs in those scenarios. And if you're the sub, what you got to know there is it is messy, because now you're not just going after the prime contractor for giving away rights, but if the government claims they think they have the rights, even if they didn't have the legal authority to do it, the prime might be in breach of that OTA or breach of that agreement. But at the same time, the government's using it and they're infringing on your intellectual property. So you got the prime and the government infringing. And to stop that, you really need to sue both of them and file claims against the government, not just suing the prime contractor. So it gets very messy, which means very expensive and time consuming as well. So all of these things need to be thought about well ahead of time before any promises are
Right. And this slide's really about, negotiating your intellectual property rights with the government. But to Sai's point, especially if you're part of a consortium, but almost certainly if you're teaming with other contractors, it's important that you also establish, your joint intellectual property rights. Anything that you're creating jointly, and I think this is just like a general thing to keep in mind on any sort of government contract or contract writ large. We see this a lot in teaming agreements and subcontracts where, it'll give the parties joint rights to any IP that they create together, but there's never anything addressing, stopping another one of the parties from materially devaluing that joint property. So just something to keep in mind, when you're going forward. You should always, try to have something in there where you're protecting the joint property, because it does belong to both or all of the creators, but you want to make sure that there's like guardrails in place to stop one of your co-creators from just like making it publicly available, such that you're never going to be able to profit from that joint property again. So a lot of things to keep in mind when you're negotiating IP. I think our next slide is on physical property. So physical property created or acquired under an OT is subject to similar considerations as IP. The critical question here is whether the government or the contractor is going to take title. So if the contractor is taking title, you should carefully consider and negotiate terms that specify conditions on the disposition of the property at the end of the OT award life cycle. So you want to make sure you're doing that and incorporating terms for determining the value of that property if the parties are sharing the costs. Then if the government is taking title, the list of considerations grows. So you want to consider everything I've just mentioned, plus the major question of who's going to be responsible for the maintenance of damage to or loss of the property once the government takes title. The next category we have is negotiating modifications. Other transactions are not subject to the same regulations as FAR-based contracts. We've said it a million times now. But in FAR-based contracts, the government must have the ability to unilaterally modify FAR-based contracts in certain respects, not a requirement for other transactions. So contractors should think through the type of modification structure that they'd like, unilateral, bilateral, and which certain circumstances would call for using either type. and structure it around what will work best for your scope of performance, and base your negotiations on these terms. Similarly, disputes falls into the same category. The Contract Disputes Act, or CDA, has no power over OTs like it would with FAR-based contracts. So contractors may wish to negotiate an alternative dispute resolution process for parties if a dispute arises under the OT. Those used to FAR-based contracts may actually welcome this change, as it maybe would be a potentially faster method to resolve disputes than the CDA, but it would still be prudent to discuss any of your ADR choices with your counsel before signing a final agreement, because as we advise all the time, not all ADR methods are created equal. And finally, in this category, we've got termination. So it's not as simple as the government's, termination for convenience or termination for the contract's default under OTA. Contractors actually have a meaningful chance to negotiate the terms of the OT's termination clause with the government. And where possible, you may even be able to impose conditions on the government's ability to terminate the other transaction. It would be great. I think it would be in everybody would love it if they could effectively eliminate the possibility of a termination for convenience, give themselves a little less risk when they're entering into a contract like this. So something to consider and push for to the extent possible. And I think our final category of what to look out for when you're negotiating an OTA is payments, accounting, and auditing. So we've said a million times now that the name of the game is flexibility for an OT. So payments on an OT are as flexible as the agreements officer can practically make it. The parties can agree on advances for large expenditures, fixed price schedules based on hitting planned milestones, or cost reimbursement, among other schemes. What's important for contractors to know is, they should have an idea of their costs upfront and negotiate for the payment scheme that makes the most sense for the contractor and for the type of work that you're doing under the other transactions award. And I think my final slide here of the presentation and about negotiating OTA is about accounting and auditing. Everybody's favorite topic. Who doesn't love the cost accounting standards and dealing with all of that? Contractors looking to enter into a cost reimbursable or research sharing agreement should note that while other transactions are not technically required to impose FAR-based accounting system requirements or audits, it's often a sticking point for the government for OTs with these type of payment structures. While DoD wants to remain as flexible as possible and be a flexible alternative to other contracting vehicles, it's one of the things that agreements officers and they'd like to have a handle on that. Where possible, contractors should advocate for flexibility at every turn, meaning not having to change their existing accounting system or seek a waiver for audits. In some circumstances, it just makes sense. If you're not a traditional defense contractor, you might not have an approved accounting system. You might just have an acceptable accounting system or something else that if the government stopped and took a look at it, they'd realize would work. So good to keep in mind that you have the right to push back on this stuff and make a case for the fact that maybe you're not following the cost accounting standards or have this approved accounting system, but you're probably following GAAP and have an acceptable accounting system. So something to keep in mind.
Yeah, and so the new language that's being proposed to be in the NDAA on, like I was referencing earlier, about broader transparency, it is pretty broad. That phrase, it says any project carried out by the Department of Defense using other transaction authority under section Title 10 shall be reported in the same manner as other Department of Defense expenditures for inclusion in the searchable public website established by the Federal Funding Accountability and Transparency Act of 2006. So because of that, if this gets passed and gets pushed through in the 2026 NDAA, which it's a fairly short, I just read the whole thing, provision, pretty simplistic, not very political, it's likely that it would be something that would be added. then that would mean that there would be more scrutiny on it, not just from the congressional side, because you think every day there's something that's fairly mundane that those in Congress or those in the government might not think anything about. But because of this, you're going to have third parties that are going to be scraping the data and looking for information, filing FOIA requests about things. That used to be something that wasn't really viable because things weren't as public or as easily accessible, even if they were technically public. And so now there's going to be more scrutiny placed on it from all different sources, or even competitors, right? That think that you're getting funding for something that maybe is already developed commercially. They have a commercial product that works better and works cheaper, and they're going to try to push that, whatever it happens to be. But if you're under some cost reimbursable model for the way you're doing work, or even certain like cost sharing, or if you've negotiated certain intellectual property rights that are based upon tracing costs as far as who developed what, all of those things I think are going to come under greater scrutiny now with this push for transparency in the OTA realm. And because of that, I think, to Josie's point, you're going to see more of the FAR Part 31 elements of the cost elements pushed into OTAs because there's already a model for it, right? There's an entire DCAA handbook about how certain things are treated. And on top of that, there's an entire body of case law interpreting what each of these different elements are. And I think that's also, by the way, just a fundamental thing to think about when you feel like there's the freedom and more flexibility with these OTAs. While that's true, if something goes to a dispute, there's not that whole body of case law that's been developed that answers a question about a regulation, because the regulation doesn't apply and it's not in the document. So instead, what it comes down to is a much more traditional litigation type dispute where a judge is going to have to come in and interpret what things mean. And that's not something that's just going to be reserved for OTAs. In all of these FAR rewrites that we're seeing, they're all using broader and more expansive language. They're removing specific elements of regulations that have been developed over time to add clarity and consistency, and that have in many cases been adjudicated in years prior. So there's case law that addresses what the specific language means. If you strip all that stuff away, whether it's in the OTA context or this new FAR rewrite, you are now opening the door for litigation to determine what each thing means, which, and with new language, means all the old case law is out the window. And someone's going to have to read it and make their best guess as to how it would be interpreted, what it should mean, and then the real question of, well, who's going to answer that? It's going to be judges in different courts, in different places. The Court of Federal Claims, for instance, that would adjudicate some of these things because they're expenditures of federal dollars. Those particular judges also are not one is not binding on the other. So you get different judges in the same court coming to different conclusions, which then have to be litigated up to the federal circuit and then potentially the Supreme Court to adjudicate what various things mean. So while flexibility sounds great and commerciality sounds great and simplification of the FAR sounds great on paper, it will likely lead to litigation, differing opinions from differing judges. And so you're probably looking at decades of case law that has been built up being eradicated and restarted. So be, I guess, prepared or just cautious about some of that when you're dealing with OTAs. Try to stick to language that might even be in certain state courts, because at least then you have something to rely upon, or things that have been adjudicated in the past, like even FAR provisions, right? Because there's case law on that. Or if you're dealing with things going forward in the future, even outside of the OTA context, just be aware that these things could come to the forefront and become much more of an issue as well. So I think with that, it's 3 o'clock. I think we have a couple minutes because we started a little late. There was one other question that I think we could answer about, do we anticipate seeing a broader definition as to what qualifies as a prototype or research project? Um, Given that this is all about flexibility, the honest answer to that, and not even just in the context of prototype and research definitions, but if the government is comfortable and if the statute doesn't clearly prohibit a use, which in most cases it doesn't, the statute's not that clear on a lot of different issues on purpose, right? It's written to give flexibility to DOT, that as long as you can make a good faith argument and as long as the government is willing to follow you down that path and they accept it, it comes down to how convincing you can be, right? Because you're really negotiating almost with the government, even in these like pre-negotiation phases, pre-OTA phases, where you're trying to say, well, no, this is a prototype, this is a research project. Here's the basics, here's why it should fit. Or even in other contexts where you're trying to get something sole sourced that is a follow-on, right? That is outside of that prototyping stage, or going in rather to the prototyping or development stage. In those sorts of things, you can push for things. And so I think that flexibility is important. And I have not heard anyone trying to clamp down on that. It's been more about the transparency element of OTAs, not trying to clamp down on flexibility, not trying to add extra rules and regulations or even pieces of the statute to more clearly define certain elements. It's still about flexibility and rapid acquisition with as much commercial elements as you can get out of it. So for what that's worth, that's where I think things are going right now, and haven't heard anything to the contrary. So with that, I guess I don't know if Josie, you have any parting thoughts before we log off here, and otherwise, I think we're good to come to an end. But of course, if there's other questions too that come off the top of your head, you have our information. We're happy to answer them. But Josie, do you have any other last parting comments?
No, just to say, thank you all for joining. And, if you have further questions, definitely send them our way. And, Sai and I did a 4-part blog series that sort of, I think you'll all get a recording of this webinar, but there's also the 4-part blog series that you can reference at any time. Just Google PilieroMazza Rise of OTA and it'll all pop up for you. So quick and easy reference.
Thank you very much. Have a good day,
Thank you all.
everybody.